this episode, we will be discussing California Landlord Retaliation against Tenant, Prohibited. The California Civil Code, Chapter 2, Section 1942.5 prohibits landlords from taking retaliatory actions against tenants that have exercised their rights under the law. Actions within 180 days. If the lessor retaliates against the lessee because of the exercise by the lessee of his or her rights under the law, or because he or she complained to an agency as to the tenantability of a dwelling, and if the lessee is not in default as to the payment of rent, the lessor may not recover possession of a dwelling in any action, cause the lessee to quit involuntarily, increase the rent, or decrease any services within 180 days of any of the following. After the date upon which the lessee, in good faith, has given notice pursuant to the laws under our video titled California Tenant Right to Repair and Deduct, has provided notice of a suspected bedbug infestation, or has made an oral complaint to the lessor regarding tenantability. After the date upon which the lessee, in good faith, has filed a written complaint or an oral complaint, which is registered or otherwise recorded in writing with an appropriate agency of which the lessor has notice for the purpose of obtaining correction of a condition relating to tenantability. After the date of an inspection or issuance of a citation resulting from a good faith complaint filed by the lessee of which the lessor did not have notice. After the filing of appropriate documents commencing a judicial or arbitration proceeding involving the issue of tenantability, or after entry of judgment or the signing of an arbitration award, if any, when in the judicial proceeding or arbitration, the issue of tenantability is determined adversely to the lessor. It is important to note, in each instance, the 180-day period shall run from the latest applicable date, and a lessee may not invoke his or her right more than once in any 12-month period. Threats to report immigration status. To report or to threaten to report the lessee or individuals known to the landlord to be associated with the lessee to immigration authorities is a form of retaliatory conduct prohibited under this section. For more information, you may see our other video titled California Landlord: Unlawful Disclosure of Tenant Immigration Status. Other threats against a tenant. It is unlawful for a lessor to increase rent, decrease services, cause a lessee to quit involuntarily, bring an action to recover possession, or threaten to do any of those acts for the purpose of retaliating against the lessee because he or she has lawfully organized or participated in a lessee's organization advocating lessee's rights, or has lawfully and peaceably exercised any rights under these laws. It is important to note, in an action brought by or against the lessee pursuant to this section, the lessee shall bear the burden of producing evidence that the lessor's conduct was in fact retaliatory. Any waiver by a lessee of his or her rights under this section is void as contrary to public policy. Damages for landlord non-compliance. Any lessor or agent of a lessor who violates this section shall be liable to the lessee in a civil action for all of the following: the actual damages sustained by the lessee, and punitive damages in an amount of not less than $100 nor more than $2,000 for each retaliatory act where the lessor or agent has been guilty of fraud, oppression, or malice. It is important to note, in any action brought for damages for retaliatory eviction, the court shall award reasonable attorney's fees to the prevailing party if either party requests attorney's fees upon the initiation of the action. For additional laws and articles, visit AmericanLandlord.com.